So good morning, everyone, and welcome to our Beasley Allen webinar presentation on navigating the next steps of the Camp Lejeune litigation. For those of you who are joining us for the first time, we want to thank you for sharing your day with us. And for our longtime viewers, we really appreciate the opportunity you've given us to help you meet your CLE requirements. So as most of you know, the deadline for filing claims under the Camp Lejeune Justice Act expired on August 10th of this year. But there's still an enormous amount of work that needs to be done as we enter this next phase of the litigation. Here at Beasley Allen, we've got an excellent team of lawyers to help guide our Camp Lejeune clients through these critical next steps. The head of our team, Ron Jones, serves on the Camp Lejeune Plaintiffs Executive Committee and the Resolution Committee, where he and other members are working to ensure that all of the impacted victims are properly compensated for their injuries. Today, I'm delighted to introduce two other very important members of Beasley Allen's Camp Lejeune team, Wesley Merillat and Elizabeth Weyerman. Together, Wesley and Elizabeth will discuss a variety of topics to include administrative claim substantiation, claim amendments, the elective option, estate issues, and settlement. Additionally, Wesley and Elizabeth will review the court-ordered litigation management platform called Rubris Crosslink. They'll also describe the short-form complaint process, and they'll provide updates on bellwether litigation. And as time permits, they're going to take your questions at the end of their presentation today. So with that, I do have a few important CLE announcements that I do need to go over with you right now. You'll give me just 1 second. Today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order for you to receive full credit for attending, you must stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered, but by the end of this week, you'll receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number. Send that to webinars@beasleyallen.com. That'll help us ensure that you receive full credit. And for those of you practicing in other states besides Alabama and Georgia, we'll send you a certificate of attendance that you can present to your own state bar. Also, be sure to check out the events page of our website, as it will give you details on our next webinar, which is set for December 11th. It's an ethics webinar featuring our own Gibson Vance, and he'll be joined by Alabama State Bar General Secretary Roman Shaw. Finally, if you got questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, I'm now going to turn our program over to Wesley and Elizabeth.
Thank you, David, for being our moderator. David does just an absolutely terrific job with this. And Elizabeth and I want to thank everybody for attending today. Again, we understand and appreciate that your time is valuable. So we're very grateful that you're joining us. Our goal today is to provide the latest information on this litigation, help you understand what we understand. Where are these bottlenecks that are happening in the litigation, how you're going to overcome these bottlenecks, so that you can help your clients understand where they're at in this process and advance their claims. And, and then Elizabeth is going to share with you what's going on inside that this courthouse that has facing 500 and some thousand claims knocking at its door. So with that in mind, we're going to kind of jump right in and cover a lot of material. Bottlenecks. If you have claims in Camp Lejeune, you are probably getting calls from clients saying, hey, what's happening? When is this going to resolve? Am I ever going to see it resolve? It's important to kind of understand where these bottlenecks are happening because understanding that can help you, in some instances, overcome that. First and foremost, let's take a look at these numbers. 550,000 plus claims is where the JAG has reported is the volume of administrative claims in this thing. We don't have the exact number. Part of that is because over 100,000 of those claims have been identified as duplicates. So these duplicates, we'll dive into, are causing a major bottleneck currently, and we'll share with you some things that you can do to help overcome that. There are additionally somewhere around 20,000 claims, plus or minus, that are in draft status, or I'm sorry, that are substantiated. Less than 20,000 are actually substantiated claims. So those are the only claims that can actually even be reviewed. The settlement, we actually don't know anymore. It used to be something that was reported. We knew that at last report there had been around 200 offers. A handful of those had settled through the elective option. We currently do not know how many settlements there are going to be, are currently, because the court has instructed the government to stop reporting those. So we'll go on to look at these bottlenecks kind of in more detail. Again, the three primary ones: there's a manual entry issue. Thousands and thousands of these claims were filed as individual claims. They weren't filed in batches, hundreds at a time. They were filed individually. Some of them were mailed in, and they had to be manually entered by JAG into their system. So that is from an administrative perspective, it's been a challenge for JAG to get these things entered and processed. Again, duplicate claims are a big part of this holdup. We'll dive into those. And then we're going to talk about unsubstantiated claims. If your claim's in draft status, how to move that forward, because that is, again, holding review and this litigation from being advanced forward. All right, the duplicates. JAG has identified 100,000 plus duplicate claims. And what this means is a variety of things. It could mean that the client went in and they filed their own claim, and then they hired you, and then you filed a claim. It could be vice versa that. It could be that the client hired multiple firms and the firms filed claims. It could be that your own firm filed a claim. You weren't sure if you submitted it the first time, and so just an abundance of caution, you went in and you submitted it again. But these claims are being identified. So there's about 100,000 of them. There's 550,000 claims total. So you're talking about 50,000 of these things that are true duplicates that are going to be coming off that top figure. The importance of this is the Navy has issued a ruling, its position on duplicates, and it's called the first in time rule. And it's following something that they follow under the Federal Tort Claims Act, which is the first claim that is filed is the only claim that will advance. So that's kind of counterintuitive, because if it could be the fact that a client hired a firm, they didn't like that firm, they went and hired a different firm, and that's the firm they want to represent them. But it's actually the first filed claim that is going to be advanced. So we want to understand how we identify if you have a duplicate case, and then what steps you can take to ensure that you're moving that forward. The Rubris platform, and Elizabeth is going to go into much more detail in this than I will, but the Rubris platform is one potential way that you can identify this. Again, we learn a lot of this by reaching out to our clients proactively. Have you hired another firm? We will get notices from other firms. Hey, look, we think we have a duplicate case. We do have probate coordinators. They will sometimes reach out to us and say, hey, we have someone else that is opening up an estate on this. But Rubris is another tool that you can use to identify whether you have duplicate claims. And this is the litigation platform that the court has ordered everyone to use if they're going to pursue a complaint, file a complaint. But one of the things that this does is you can upload all of your cases and the data in your cases to Rubris. You can then manage those cases. And so within Rubris, and there's a screenshot of this here, you can see on the left-hand menu, projects, information resources. You can see where it says claims. And at the bottom, you can see where it says duplicate management. That's actually not where you go to see if if there are other firms that have potential claims. So that is just a place where you can see if you actually filed duplicate claims within your own firm. But to see if another firm who's using the Rubris platform has filed a duplicate claim or a claim that's potentially a duplicate, you would go down to where it says claims, and you open that up. And then you go into these advanced filters on the right-hand side. And under the filters, you're going to see where it says statuses. And you can select a status of these claims. And then you'll see when you open that window up, you can look at internal duplicates and you can look at external duplicates. And when you go down and you run a report for external duplicates, it will produce all of your claims that are potentially have another firm that are involved in that. So again, that's another opportunity to reach out to those clients and say, hey, is it possible that you had another firm involved in this? The Navy had initially been reaching out to firms and letting them know, but they're no longer doing that. So this, again, Rubris is another tool that you can use to identify those duplicate claims. The next big issue is what are you doing with your claim? A lot of people have these claims that they file it and then they think, okay, well, it's filed. I'm kind of going to sit and wait. And that isn't going to move the claim. The Navy has to have the ability to evaluate the claim. So what they're saying is, again, 500,000 total claims when you back out all the duplicates. 480,000 of these claims have not been validated. So the Navy cannot evaluate whether this is a claim it can resolve or not. So it's important that you look at every one of your cases and understand whether you have the three evidentiary criteria that are going to be needed. Do you have what we call basis or relational evidence? This is the evidence that shows why are you on the base? What right do you have to be there? Is it employment? Is it you're a dependent, a family member? Are you in the military? Your exposure evidence, your military documentation, your employment documentation. When were you there, how long you were there, and then your injury evidence showing supporting the medical conditions that you have. If this is the documents that are needed in order to validate a claim. I included here a glossary of various claim statuses. I won't review all of these with you, but it's helpful to kind of understand two in particular, and I've highlighted those for you. The first one is draft in red. The claim has been opened, but it has not been officially submitted for processing. So you can go into the portal and you can see what your draft or your claim status is. Is it in draft status or is it in submitted status? Or if it is in draft status, it means that you can go in and continue to update it. It may mean that you still need to submit documentation. It may mean that you submitted your documentation, but you just haven't formally submitted it, went into to the platform and submitted it formally to the Navy. So it's important to understand what status your case is in, and if it's all ready to go, making sure that you've properly submitted it within the portal. So again, these are just kind of the various statuses to look for when you're in the portal on your claims. All right, so again, duplicates are a big issue. And so we're going to talk about if you've identified a duplicate, what's the next step? The claim substantiation is a big issue. Again, the Navy's saying we've got basically 20,000 claims that are ready to be reviewed. So 480,000 are just sitting there. So if you want to advance your claim, we'll kind of talk about how you do that, what you need to specifically do to review that claim, update or amend it, and then to make sure that you're substantiating it with the needed documents. All right, if you have identified a duplicate claim, you can go back onto the Navy's portal, and this is where you're going to take the steps to ensure that the claim, whichever attorney is handling this claim is the firm that is named on the first filed claim. So again, the Navy's position is only the first filed claim will advance. If your firm is the first filed claim and you're going to continue representing the client, there's really nothing you have to do. You just continue to work on that file. If you are not the first filed claim, but you are going to take the lead on this, then you need to coordinate with the client and or the dual rep firm to make sure that they're going into this portal and they're formally submitting a request to change counsel. So you can see there, one of the form abilities this form has is to enter a substitution of counsel. So this is where you're going to go in. You have to formally go inside of the portal and make this formal request. So again, that's something you're going to have to coordinate on a claim by claim basis wherever you have a dual rep with the dual rep attorneys if there are one. The claim portal. Again, the status of your case is very important in understanding what you can currently do with that case. If you're in draft status on the portal, that means you can go in and you can make changes to the claim, you can update the claim. There aren't any restrictions on that. If your claim has been submitted, then you may still be able to go in and update certain things, but they cannot be substantive updates. So you can go in and you can change counsel, you can change contact information, you can make a request to upload documents. If you're making a substantive change to the claim, you're going to have to formally make a request to amend. And again, you can go into the portal and there's a section in there where you can make that request. So things that would constitute a formal amendment would be you're modifying or changing the injury that was initially claimed. You're changing the exposure period that they were at Camp Lejeune. You're changing the amount of money that you're requesting. If you make any amendment, it will reset that 6-month period that the Navy has to review it before you're permitted to file a suit. So you have to be real mindful of where you're at in the by status wise, and then are you making an amendment or is it something that you're really updating? If you are in draft status, the Navy has also identified this as a bottleneck issue. The number of claims that are still in draft status, they will force the status change on your claim on January 13th, 2025. So up until that day, if you're in draft status, you can make theoretically all the changes you want. Once January 13th, 2025 comes, if you're still in draft status, the Navy's just going to convert it to a submitted claim, and you will have to formally make a request to amend, even to go in and change something as little as contact information. So everything will be considered be a required formal amendment after that date. All right, so what do you need again to document this, document and properly substantiate a claim in the portal? When you submit a claim in the portal, there's going to be 3 sections that you will encounter where you need to submit documentation. So if you submitted this pre-portal, you did it on a form, you emailed it in, it's likely that you probably didn't submit any documentation. So you'll have to go into the portal and you may have to formally send JAG a message that you have documentation you would like to submit. And then they will respond and that'll give you the opportunity to submit it. If you submitted it via the portal and you're currently in draft status, you can go in and you should still be able to see these 3 sections where they're asking for documentation. The 3 areas that they're looking for are, again, what we call these basis or these relational documents. Records that demonstrate why are you on the base? Why was the claimant there? Were they in the military? Were they a family member? If they were a family member, they're going to have the sponsor's military documentation, and they're going to have to show a relational document, a birth certificate showing they were a child, a marriage certificate showing they were a spouse. So those are the things that would be uploaded in that section. Exposure records, again, any records showing that both when they were there and the duration that they were there. These are typically service records, but they can also, we've seen photos. We have clients that have submitted letters that they've kept with the address on there. So anything that you have to prove that exposure, substantially is what you want to make sure that you upload there. And then injury records. Sorry, Elizabeth, I wasn't moving fast enough. And then injury records, you want to make sure that you have diagnosing records are really the best. And we know that a lot of these injuries happened a long time ago, so those records may not be available, but you want to upload your best evidence. If that's a diagnosing record, terrific. If it's a record reflecting past medical diagnosis or past medical history, great. If it's an affidavit of injury, if that's all you have, make sure that you have something uploaded there. All right. Elective options. Our understanding is the only cases that have currently settled are elective option cases. And if you're not familiar with it, again, on this slide, an elective option case is you were there 30 or more days, you have a specific tier injury. That injury was diagnosed or treated within 35 years. There's a minimum, you can't have it within 2 years of when you were first there. But typically 35 years from when you were last at Camp Lejeune. And then it is a very objective grid that you're going to see right there. That award ranges from 100,000 to 550,000. And again, it only covers these tier diseases. So if you think you have an elective option claim, there's some steps that you can take to actually draw attention to it and get the Navy to review that. So we've actually tested this. We have resolved, and we're actively resolving elective option claims. So if, again, you have an elective option claim and it's something that you've talked with your client over and it's something that seems to be something the client wants to pursue, what you're going to do is you're going to make sure that you have your exposure records uploaded to the portal. And you want to make sure that you have diagnosing records uploaded to the portal. Again, the likelihood of diagnosing records being available for an elective option is much greater than most administrative claims because it is this 35-year threshold. So it typically is individuals who were there later at Camp Lejeune that we're seeing, but they will, they're not inclined to automatically accept medical records that show past medical history. Now, we have cases where that's all we have. We do not have the original diagnosing records. And honestly, we're in the process of submitting those records, proof that those records no longer exist to JAG. But we do have later medical records showing a past medical history of that. So we don't know how that will play out yet, but JAG is specifically requests diagnosing records. And they really should be certified records. If you don't have those, you have to explain to JAG why you don't have them and the efforts you took to get them. You're going to get those records, make sure they're uploaded into the portal, and then you're going to go into the portal and you're going to send JAG a message, a simple message that says, client would like case reviewed for elective option. Again, we've tested this. JAG responds to the message, and in some cases they will review and they send you an offer. In some cases they have said, hey, can you submit some additional documents? But it is a tool that we have seen effectively engages them. So you don't have to do it. You can sit there and JAG will review every single claim. They have said this for an elective option. But again, these are some things that you can proactively do to make that process move a little quicker. If you get an offer from JAG, we can tell you that it moves very quickly. Offer to payment can often happen within 30 days before money is in the hand. So it is something that it goes very quickly. There are plus sides to it. There are, again, it's very quick for the client's perspective. The attorney fee gets capped, so there's more money in the client's pocket. The VA, Medicare, they're not seeking offsets or liens. And really, most importantly, this is very objective criteria. There's no causation proof or issues. There's no, aggravating factors that they're going to take into consideration. Prior medical history, comorbidities, anything like that. They're just going to look at, were you there 30 plus days? Did you get a tier disease within 35 years? So smoker, non-smoker, none of that is going to play into this, where it will definitely play into perhaps the admin claim or the litigation. So you'll get that settlement agreement, and then again, the Department of Treasury wires you those funds. So again, the EO is something that is an opportunity. Review your claims for it, and you can move that forward by just sending that message in the portal. Okay, this is where I'm going to turn this over to Elizabeth. She will take you back into, from firsthand experience, really the bellwether part of this and beyond the administrative claims, and give you a great understanding of that.
Thank you, Wes. Hey, everyone. My name is Elizabeth Weyerman, and as Wes said, my focus today will mostly be on the Camp Lejeune litigation and bellwether specifically. I have the pleasure of helping with the bellwether committee with plaintiff leadership, and so that is most of my case experience here with Camp Lejeune. As far as focusing just on filed claims, like Wes said, there are over 550,000 administrative claims, but there are currently over 2,000, a little over 2,000 filed claims in the Eastern District of North Carolina. There are, at this point, 4 judges in the Eastern District who are helping with those claims. Now, there has been discussion that if other judges or more judges are needed, that they might be pulled in from other districts, but at this point, it is the 4 in the Eastern District. And right now, there are 2 different injury tracks, track 1 and 2, which I'll talk more specifically about here. So you can see the different injuries that have been consolidated into these tracks for bellwethers. The first track of bellwether trials, these test trials for track 1, are expected to happen next year. So there's currently 25 cases going to trial, 5 for each of these injuries listed. Our hope is that this first round of bellwether trials, when they're complete, that the government will begin making reasonable settlement offers, especially for these injuries. So the average amounts of any Camp Lejeune lawsuit payout, these awards, they will hopefully help us work towards a global settlement, and we are already looking forward to those negotiations. And so hopefully these trials will help us understand how each judge is likely to respond to future cases involving these different types of injuries. I encourage all of you to look at the recent status report that was filed on April 19th. In this, the government proposed a 3rd track of Camp Lejeune diseases, and these would include esophageal cancer, miscarriages, dental effects, or hypersensitivity skin disorders. There's also medical monitoring unrelated to a specific disease. So thinking about the volume of these claims, the U.S. Attorney has argued that incorporating these additional claims through track 3 would help us progress the litigation. And I tend to agree. The U.S. government has argued that medical monitoring not tied to a specific disease does not fall into the purview of recoverable damages under the statute. But plaintiff leadership group's opinion is that, and they've argued in that status report I mentioned, that the diseases selected by the government will not significantly contribute to resolving the litigation. It will present its proposal for these track 3 injuries in the next status conference, which is scheduled at this point for April 26th. And so hopefully we can look forward to track 3 as well. So before I move into the trial structure, I want to give just a brief update about what's happening in track 1 and 2. So like I said, track 1 currently has 25 trials that are scheduled to begin next year, and they're in discovery. So right now, plaintiff lawyers are concluding final depositions of 3 key fact witnesses, which include Dr. Bove. He's an epidemiologist who has been involved in studying Camp Lejeune's toxic exposure impact. There's also Susan Martell, who's been associated with relevant research through the National Academy of Sciences, and also Scott Williams, who's an environmental programs manager for Marine Corps Installations East. So he oversees environmental initiatives at Camp Lejeune. So for track 1's, plaintiff's general causation expert reports are currently due in December, so next month, and it's coming up. And then plaintiff specific causation experts are currently due in January. So Daubert rulings will likely take place in early to mid 2025, so prior to these bellwether trials. So track 2 submissions are happening right now. We have currently emailed over 80 of those submissions that we have. If you feel that your firm or you have a track 2 potential bellwether case for prostate cancer, kidney disease, lung cancer, liver cancer, or breast cancer, especially we would like new submissions for lung and liver cancers, please email me and I'm happy to send you that link that will have your submission go directly to the Bellwether Committee. We will consider it, and if we feel that it's a potential submission to the court, then we will interview your client. I'd be very appreciative, and I know the entire committee would be, especially for lung cancer cases that have not previously smoked and liver cancer cases in general. And as Wes stated earlier, any individual cases that are not selected for discovery, those are stayed at this point. Now, just talking about the different trial structure and generally, if phase 1 would be the water contamination, phase 2, general causation, then we would move into phase 3, which is specific causation, and phase 4 will, of course, be damages. So talking briefly right now about just the water contamination phase. So I'm sure that you have probably all seen the ATSDR report at this point. However, of course, that's not being taken as gospel. So during this water contamination phase of trial, parties will present evidence on the levels of water contamination at Camp Lejeune from 1953 to 1987. And so then the court will make a determination on what chemicals were present in the water at that time and in what concentrations and in different areas. As I'm sure that you're aware, there are different water treatment plants and different water sources for Camp Lejeune in that time frame. So the plaintiffs will also present evidence on various pathways of exposure during this phase of trial. So that would be drinking the water, showering, inhalation. If you worked in certain areas or had certain jobs, I know that we've seen plaintiffs that have worked in the dry cleaners or were washing tanks outside during the day. All of that will be taken into consideration into this water contamination phase, where you lived or the different jobs that you worked while at Camp Lejeune. It does affect your exposure and the different kinds of water and toxic chemicals that you were exposed to in this time frame. Now, talking about general and specific causation, the second and third phase of the trial. So, of course, the court has ruled that plaintiffs have the burden of proof on general and specific causation. So in order to prove causation, plaintiffs are relying on expert testimony, and the parties are actively engaged in expert testimony right now, or an expert discovery for these tracked ones. And so, of course, this includes working with experts for water contamination, medical doctors, experts, and then exposure experts saying how you were exposed and to what severity that would lead your body to intake these chemicals and for how long. So during this general causation phase of trial, the plaintiffs will be required to prove that a particular type of harm, so for example, kidney cancer, can generally be caused by a certain toxin and to a certain degree of scientific certainty. But when it comes to this specific causation, that would be specifically that plaintiff's injury. So that plaintiff's kidney cancer was caused by a certain toxin or toxic water at Camp Lejeune to a certain degree of scientific certainty. And of course, I won't give you all the details, but as far as the Bellwether Committee and expert workup right now, we are considering that certain injuries are more closely linked or have a closer causal link to certain chemicals, of course. And so that is being considered. And then which chemicals were present in certain time frames, and in different time frames, certain chemicals were more heavily present than in other time frames or locations on the base. So during the fourth phase, that damages phase of trial, of course, the plaintiffs will present evidence on the damages suffered as a result of the toxic water exposure. And that's probably what most everyone is most familiar with. That includes pain and suffering, lost wages, medical bills, wrongful death cases, the lost value of your loved one's life. And so that will be the fourth phase of the trial. I want to talk just briefly about the different case management orders and what I think might be helpful to you in your case workup. So CMO 1 did establish plaintiff leadership. And if your firm is doing any common benefit work, so working up, doing case workup that will help resolve every case, those details are covered in CMO 7. Now, there has been additional literature provided that would help you understand how to submit your common benefit time. If that's something that you might have questions about, feel free to email me and I'd be happy to provide you those extra documents or answer questions that you have about is certain work covered under common benefit. CMO 9 established track 2s. And then I do believe that the most important overall CMO probably for everyone here is CMO 2. So that not only established track 1 injuries, but it also lays out how to apply for Rubris Crosslink, which is what I'm about to talk about. And it also helps explain how to file a short form complaint. So like I said, CMO number 2 gives you detailed instructions about how to apply or sign up for this Rubris Crosslink. And if you have specific questions about it, of course, email me. I'm happy to answer them. But Rubris Crosslink was chosen as the litigation management database. I actually enjoy it, and I think it's pretty user-friendly, and so hopefully you won't have any issues with it. Now, Rubris generates the short form complaint. So once the case has been filed in the Eastern District of North Carolina through PACER, it will automatically update and populate on Rubris once you have used Rubris to generate that short form complaint. So you do not have to go through PACER every single time to view it. It'll save you a little bit of money, and I think Rubris is a little bit easier to use. So through Rubris, you can see what's been filed, which judge has been assigned to that claim, its case number, and any outstanding requirements that the court has issued. So if you filed a case, then the case information box will show what's filed. So that's this box right here. So it'll show what's been filed, it will show if it's been served on the Navy JAG, and it will show if there's an amendment of service, and any additional information should be below that relates to the case. So this page shows you how to create a claim in the portal. So you can see that this page goes into great depth about the plaintiff and information. So if the claim is a wrongful death claim, then this is where you will include the estate representative and the estate attorney information. Now, the court has ruled that once you file a claim, it does need to have the estate open. So you will list all of this here. So the Navy does report that, like Wes said, there are over 100,000 duplicates. And so even if you do not choose to file a short form complaint at this point, it is important that you go ahead and upload your administrative claim information into Rubris as much as you can. It helps plaintiff leadership understand and negotiate for settlements for the different injuries. It also helps us know if there are duplicates out there. And so it is most helpful to go ahead and upload everything in Rubris. And just in my opinion, for you personally, it will help you keep up with your different claims. And so that's just one of the many reasons why it is important to file through Rubris. And if you have any questions, I'm happy to help you there. Now, Court Order 47 did order all plaintiffs to use Rubris. However, the court later softened their approach here, and there are now printable versions, which is what you're looking at here, of the short form complaint on the Camp Lejeune litigation portal. So right here on the slide, page 2 includes exposure information, which includes the month that the claimant was at Camp Lejeune, why they were at Camp Lejeune, whether this claimant was a member of the armed forces, or trying to figure out if they were a dependent or a civilian worker. So of course, much of this information is this exact same of what you included on the administrative claim. And so hopefully if you do decide to file or need to because your administrative claim has been denied, filing the short form complaint should be pretty simple, and you can take much of the information from the administrative claim. So on this next slide, you can see this list here. The list of injuries, of course, is not exhaustive. And so there is this box to list other injuries on the form. And then box 28 that you see here allows you to check if there is a derivative claim to be filed for dependents, loss of consortium, mental anguish, etc. So these additional damages are encompassed under the main claimant, who was the service member. Of course, if these dependents have their own injuries, you'll need to file a short form complaint for them to have their own claim that way. So if the federal government, like I mentioned, outright explicitly denies or rejects the administrative claim, then it's our position under the Federal Tort Claims Act, ours as a firm and as plaintiff leadership, that the claimant then has 180 days to respond and file the short form complaint here. So it's our position that there's no need to file a short form complaint unless the administrative claim is expressly denied, and you would be notified by Navy JAG. So if this happened, then this box that you see right here in number 30, this ID number that you must list, it's shown on the portal, and that would be the number that is shown as CLC dash, and then there will be 9 digits. So this is how you would need to enter it here. And so hopefully, I know Wes mentioned there might be some theories or some strategy as to why you would want to file a short form complaint, but it's our position as plaintiff leadership that you do not need to file a short form complaint unless your administrative claim is expressly denied. So we're hopeful that these bellwether trials do move us towards a global settlement. We are working extremely hard to work up these cases. If you have any questions, please do email me, but I do encourage you to submit claims, and I can email you the link to do so for track 2s. And then once there are track 3s, hopefully we do get there, that you will submit for those as well. It's extremely helpful to plaintiff leadership, and we have a very good time working with you to try to decide if they would be a good bellwether potential to submit to the court. So that's all I have for bellwether workup and trial litigation, and I'm going to give it over to David to hopefully facilitate our questions.
All righty, thanks so much, Wesley and Elizabeth, for a fantastic presentation. We have received a number of questions during your talk, and if you'll allow me, I'm going to present them to you and try to get your feedback. If we don't have time to catch your question, please submit your question to us at webinars@beasleyallen.com. So our first question comes from Christine. Christine asks, what if a claimant passes away during the administrative claim process as a result of a Camp Lejeune connected injury? In that case, should we amend the substance of the claim to change the injury for personal injury to wrongful death? Who wants to tackle that?
Yeah, so you would want to amend the claim for a couple of reasons. One, you are going to need a legal representative now. So you're going to have to facilitate that appointment and then upload that information into the portal. You're also going to want to update the claim to include a wrongful death. It's not to the exclusion of the personal injury claim anymore. It's just if the injury itself was related to that death, you're going to want to go in and upload that.
Okay. Our next question comes from Bailey. Bailey asked, how do you suggest addressing claims where the decedent died 20 plus years ago and all medical records have been purged? How do we prove the medical condition in that situation?
Again, so this is a common issue. If you've been exhaustive with the medical records, sometimes, you submit a medical record request, the facility says, look, our retention policy provides that, we destroy them after 10 years or we don't have them anymore. I'd keep that document because I think that document is evidence that I would attach to an affidavit of injury. Stating I was diagnosed, I had the injury, here are my efforts to order those documents, see attached, and then you submit that. So we have, in some cases, had to submit, an affidavit of injury where there just is no records out there.
All right, our next question comes from Miriam. She asked, can you have the first filed claim withdrawn so that the only open claim is the one that you want to proceed with?
I do not know, and I wouldn't test that unless you heard directly from the Navy. There is a mechanism to withdraw a claim, but the Navy's position is only the first claim will advance. So if you withdraw that, I don't know that it automatically leaves the remaining claim viable. So I would that'd be something I'd reach out to the Navy and to seek clarification. We haven't been involved with withdrawing a claim for that purpose, but I wouldn't do it without getting clarification.
You guys may have addressed this already, but just in case, Jamie asks, is there a deadline to amend?
They're not technically. In January, on January 13th, you're going to have to seek a formal amendment to make any updates to the claim. Prior to that, you can update the claim if you're still in draft status. So if you've already submitted it, you still may have to go in and make an amendment, request to amend. But, let's say next March, you discover some new records or your client passes away. You can still go in and make a formal request to amend all the way up until there's, it's been reviewed and there's a decision on it. But again, any amendment will extend that 6-month period.
All right. Next, Michelle asks, these claims have been submitted using several different methods. Initially, it was emailing a form. Then it was through the Navy portal. Now it's by utilizing the Rubris platform. Which of these methods is considered the first submission?
The first submission is considered the first submission, I think. Initially, if you submitted this via email, if you go into the portal, you ought to be able to see the date that it was initially submitted, the submission date, and then there's maybe a portal date, the date that it was uploaded into the portal. So it really is going by the date that the earliest date that you submitted it.
Christine has another question for you guys. She asks, on the administrative claim forms, there was an option to select estimated or exposure date. How are these handled in the EO review process if it turns out the estimated dates are not exact, but the claim is still eligible for an EO?
Yeah, that won't be an issue. I think in the majority of ours, we estimate, if we don't have the day, we have the month and year, we may put that down. If we just have the years, we've estimated that. And then, we submit them often early on. Sometimes we don't have those military records. The JAG is going to review it. They're going to have those records. And they're going to obviously, duration that you were there is really critical, because if you're there for more than a year, it takes you up to another tier. So you can estimate, but if your estimation is between, you were there 2 years, but maybe 3 years, it doesn't really make a difference. It really applies to where you're there at least 30, or you there more than 1 year, or you were there more than, the 5 years.
All right, that's very helpful. Our next question comes from John. When you submit a medical record, should it be the entire record or just the pertinent pages? For example, if you have the entire record for an admission, you just submit the pathology report or the entire record?
My position on it would be, I would submit the diagnosing record, and I would even go so far as to highlight the diagnosis. I would not be inclined to submit 1,300 pages of VA records and then rely on the human reviewer on the other end to search through them. It'd be easier for them to ask you for additional records, and they've done that for us. They come back and said, hey, we have past medical history. Do you have a diagnosing record? And they only asked for the diagnosing record. They didn't say send us everything. So I'd start with just that best record.
Okay, good advice. Our next question is from Beth. Beth asked the following: for the elective option, what if your client has a tier 1 and tier 2 injury? Are the amounts combined? Also, follow-up question, must the elective option be accepted once offered?
So to the first part, they will only take the highest tier. So if you have a tier 1 and that results in the highest payout, that's what they're going to pursue. They will not combine them. You only get paid for one injury. So we have had clients that have had multiple tier injuries, and it's a conversation you have to say you're only going to get compensated for one, but you're going to have to waive and release all your other claims. So whether that makes sense in that situation or not, is very, client specific. As to the if you're given an offer, no, you're able to, reject the offer, decline the offer. And if you do, it'll just go under administrative review.
All right, very good. Our next question is from Wendy. Wendy asked, with a short time span to accept elective option, how are you handling Medicaid and private liens so that you know what those liens might be before determining whether the client may want to accept the offer?
That is a terrific question. Nothing drives us more crazy than liens. The client sees a number that says 300,000, and then you have to go through this whole lien thing. And at the end of the day, it's a battle with Medicaid about how much money they're going to take. We've been proactive. We've engaged, with lien resolution companies. When we go to submit these, we are looking at gathering that information and looking at the if there's any remote chance that it's private, if there's a remote chance that it's state Medicaid, we will go in and proactively look at those liens. I will say that 60-day window it's mandatory that the government give you 60 days, but after the 60 days, they may withdraw that offer. So you could work with them to say, we're still working on this. Could you extend it? So it's not a hard deadline that the offer expires at the 60 days.
Our next question comes from Laura. She asked, do you have any insight as to settlements outside of the EO that may occur at the administrative level? She says she's received messages from the Department of the Navy that they, quote, want to recommend a case for settlement, end quote, and to send additional info. But the clients they're contacting us on clearly don't qualify for the EO. One was diagnosed 53 years after his last exposure.
So here's what I'm thinking happens. Is initially the Navy said, we're going to focus on EO first. And then we're going to take that model and we're going to look at the administrative claims. But they have had, out of the 500,000 so claims, when you back out the duplicates, only 20,000 of them have submitted documents or have been fully submitted. The rest are in draft status or not validated. So they very well may be looking at claims that beyond EO, because they don't have any EO, claims to review, or not a volume to review. So I'm not aware of any administrative claim settlement, but yeah, we've seen where they have asked for some documentation.
All right, I think we've got time for two more questions, and I'll hit those real quick. The first one is from Kyle. Kyle asks, for submitting substantiating documents, do we have to formally request an amendment, or can we submit them by sending in a message?
So if you're in draft status, you should be able to go into the file and submit them without any request. If you've been submitted, I don't think you have to go in to make a request for an amendment, but you would just simply message use the message feature in that case, and then advise them that you have some documents. They will then respond, and you can upload the documents into via that message system.
Okay. Let me do one more question from Kyle, and then we'll wrap up. Another question is, do we need to have all substantiating documents submitted by January 13, 2025? If not, what's the process to submit after that deadline?
So no, you do not have to. Just if you have enough documents that they can review the claim, they're going to review the claim. But if you have documents past that date, you're still gonna you would just ask the Navy, you'd advise them that you have some documents that are needed to review the claim, you'd message them, and then you would go in and upload them. So again, I don't believe that's going to reset the 6 month, but because you're not really changing the claim, you're just providing the documentation. But you are gonna have to message them after that date.
Well, thanks to both of you again for a wonderful presentation. And for those of you who presented questions that we didn't have time to get to, again, I want to encourage you to just cut and paste those into an email to webinars@beasleyallen.com, and we will do our very best to get you those answers. And for those of you who may have missed our earlier announcements, by the end of this week, you'll receive an email with a certificate of attendance and an updated presentation and video link to today's program. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for our Alabama and Georgia attorneys who are participating by phone, please email us your name, your phone number, and state bar ID number to webinars@beasleyallen.com. That'll help us ensure you receive full CLE credit. And for those of you who are practicing in other states, we're going to send you a certificate of attendance that you can present to your state bar. Last but not least, be sure to check out the events page of our website, beasleyallen.com/events. It'll give you details on our next webinar, which is scheduled for December 11th. It's an ethics webinar featuring Beasley Allen's Gibson Vance and our Alabama State Bar General Secretary Roman Shaw. Thanks to all of you for joining us today, and thank you for supporting our Beasley Allen webinar series. Have a great day.